Your Honor, while we're waiting on Mr. Scheck, who is discussing something with Mr. Morrill, I'd like to go ahead and move some exhibits into evidence for the record. I'd like to move into evidence Defendant's Exhibit 20, which was Dr. Roberts' curriculum vitae. Defendant's Exhibit 21, which is the OCME file from Nishonda, Washington. Defendant's Exhibit 22, which is the OCME file for Doris Washington. Exhibit 23, which was a blow-up of a page from Doris Washington's OCME file. Exhibit 24, which was a blow-up of a single page from Nishonda, Washington's OCME file. Exhibit 25, which was the picture of the liver. Exhibit 26, which was the distant photograph of the uterus or the pelvic block. Defendant's Exhibit 27, which was the close-up of the uterus or the pelvic block. And Defendant's Exhibit 28, which was the diagram that I worked on with Dr. Roberts to illustrate the testimony.
All right. Your motion is allowed. Yes.
Well, Investigator Soucy, Michelle Soucy.
And because nothing about a word like, do you solemnly swear that the testimony that you should not give the court to be the truth, the whole truth, and nothing but the truth, so help you God? I do. You receive.
Can you please state your name for the record
Michelle Soucy
and where you're currently employed?
at the Durham Police Department in Durham, North Carolina.
And how long have you been employed there?
A little over 17 years.
Oh, 17 years as of today?
A little over 17 years as of today, yes.
Okay. And Investigator Soucy, there came a point in time, I believe on December 5th, 2011, that you were assigned to this case.
No, I was not assigned to the case.
Well, let me ask you, were you tasked by a Sergeant Pennica to do something with respect to this case?
Yes, I was.
All right. Now, you kept records, did you not, of all the things you did in the course of your activities with respect to this case?
Yes, I did.
And that involved ultimately tracking down Jermac Jones,
That's correct.
getting his criminal record.
I didn't pull a criminal record, no.
You didn't look at his criminal record?
No, I did not.
Talking with his probation officer,
That I did, yes.
arranging to have somebody from the laboratory come and take a buccal swab from him.
Somebody from the laboratory?
So, an individual to come and take a buccal swab for purposes of getting his DNA.
One of our forensic technicians, yes.
Yes. And you kept track of everything you did, correct?
That's correct.
All right, so let me show you some exhibits to see if we can move this forward. First, this would be one. What's next? First, let me show you what would be Defendant's 29, which has date stamps 12/5/1 to 12/88. Okay. And Do you recognize this as a production that was made to the defense by the prosecutor's office that includes, on the first page, there's a disc, correct? Xerox of the disc.
That's correct.
All right. And that was a disc that you secured, that was a videotape of your discussions with Jermac Jones and discussions with the Sergeant Pennica and the taking of the buccal swab at police headquarters on what date?
December 14, I'm sorry, December 14th, 2011.
Right. And you secured that tape,
Yes,
and you made it in the form of a disc.
that's correct.
And this was kept in the normal course of business, correct?
I submitted it, excuse me, I submitted it with the paperwork, and that was the end of my involvement, yes.
Right. And the paperwork is essentially what is Exhibit 29, correct? Take a look. Take your time.
Yes.
Okay. And I'm going to separately mark as defendants 30, a copy of the search warrant and inventory in this case, which is included within the larger set of materials, correct?
Yes, it is.
Okay. And then, finally, as defendants 31, I would like to mark a series of emailed communications that was produced to us from you that starts on date stamp page 2575. And in the course of your testimony, if you need to look at any of these to refresh your recollection as to events, please feel free to do so, okay?
Okay.
And you've reviewed those before you came in here to testify, correct?
The emails, no.
Well, okay, but the rest of it you did.
My search warrant and my notes, yes,
Okay.
that's it.
And now, with respect to the tape of the interview that you conducted and Sergeant Pennica conducted and the taking of the buccal swabs from Mr. Jermac Jones, you had not reviewed that tape until recently, correct?
You mean the recording?
Yes,
Okay.
but however you want to refer to it.
I had not reviewed this until Friday of last week.
Right. And to your knowledge, in your discussions had anyone in the district attorney's office reviewed that until the defense called it to your attention that there was something on that recording?
I don't know who reviewed it and when they reviewed it. I have no knowledge of that.
You have been sitting here watching the testimony in this hearing, have you not?
Yes, I have.
Okay. Now, have you reviewed any other documents in preparation for your testimony other than the ones that I just gave you?
Any other documents?
Yeah.
Not that I recall, no.
Okay. And have you talked to Sergeant Penica prior to coming in here and testifying about this case?
No, I have not.
Have you talked to Miss Ellis and Mr. Morrill?
Yes, I have.
How many times?
On Friday, we met.
Friday of
Last week.
That was the only conversation?
Yes.
And what about since the hearing began on Monday and Monday night?
About the facts of the case? No, no conversations.
Well, what did you talk about with respect to the case?
Other than that you were going to call me to testify? I'm not sure I'm understanding the question, because
Okay.
we have not had any discussions regarding the case. She's been in the courtroom, I've been sitting there, and
Huh.
we haven't met, we didn't meet at lunchtime.
All right, I'll get to discussions about the tape itself and the transcript, okay? Have you talked to, do you know an investigator, Protka?
I don't know him. I saw him in the courtroom yesterday, and apparently he used to work for the police department. I've never met him before.
You'd never talked to him about this case?
I've never met him in my life until yesterday when he sat on that bench.
Is he here in the courtroom today? I don't even know.
Your Honor, I can say
I don't
that
think
he is
so. I don't
on-
remember
he's on
really.
telephone standby.
Okay. What about an investigator, Muse?
Have I spoken with Investigator?
Do you know
Muse?
him? Have you spoken to him at all about this matter?
No.
All right. What about former Captain Sarvis?
I know him. I have not spoken with him.
Okay. You know Mr. Nifong,
Yes.
and you worked with him on the Duke lacrosse case?
Yes.
All right. You have a friendly relationship with him?
Friendly. I have had a working relationship with him.
Okay. Do you think that he hid exculpatory evidence in that case, from what you know?
I don't know anything about this case until my involvement in 2011.
I'm not,
So-
not talking about this case. I'm talking about the Duke lacrosse case.
I don't know that I'm allowed to speak about that.
Well, I'm asking you the question. You can answer it.
Do I think he hid anything? I was
Your Honor,
not in the
I'd say
courtroom
that
that
during
calls
the
for
case.
speculation.
Just move.
So,
Okay.
I'd say that that calls for wild speculation. If she knows, she knows. If she doesn't, she doesn't.
Well, that's why I'm asking.
Then she can answer.
I was not present in the courtroom during that case, so I do not know if he hid anything or not.
Are you aware that there are allegations that he hid exculpatory evidence in this case?
That he hid his culture?
Yes.
I'm not aware of that, no.
Okay. And I'm just trying to assess your feelings one way or the other about Mr. Nifong. Do you feel that he was treated fairly by the courts and the state bar with respect to the Duke
Your Honor,
lacrosse
I'd
case?
say that that's irrelevant.
Only as to her credibility.
Overruled. You can answer. If you have a...
I don't know, have any knowledge of
Okay.
what the outcome was of that.
You don't know that he was disbarred?
I heard that he was disbarred, but I don't know what the reasoning for it was.
So in other words, you didn't follow any of that?
I did not.
Okay. Now, in your record of your activities in this case, and I'm calling your attention now to date stamp number 1280. You see that? On Exhibit 29. You see that page?
You're talking about the reporting officer narrative?
That's right. Yes. Okay. And what is a reporting officer narrative?
It's the narrative or supplemental that we put in an investigative report in the computer system that we use.
Right. And at the very top of that, it says, these notes are in reference to follow up on a 1991 homicide case that had already been solved and prosecuted in the courts. Refer to original incident number 91-143809 for details on the case. Do you see that?
Yes.
Okay. And I'd like to mark as, what's next in order? Where are those? I think I'm running out. Okay. I'm going to show you a document, but that's 91-143809. That is a reference to the police department file on the homicide of Doris Washington and Nishonda Washington, right?
That's the case number I was given, yes.
Okay. And so 32, would this not be the way that the records are kept, that this is the folder that says Detective Division Confidential Case Information, lists the offense of homicide, and it gives the case number, right?
It appears to be. I've never seen this before.
Well, didn't you go and look at a file on this case?
No, I did not.
Well, aren't you referencing this file?
That's the number I was given to refer it to when I did this new report, because in our system, I could not access this report because we did not have it in the computer.
You couldn't go and get the actual Detective Division file and the list of exhibits that are contained
I was not
within it?
able to do so at the time, no.
Could Sergeant Pennick have done that?
I don't know. I don't know even what building it would have been housed in.
Well, but in the ordinary course of business, you have a file on the case, and even in the post-conviction, you use the same number, right, to continue to put records into the file on the case. Fair enough?
Normally, you would if you were able to do so, but our computer system did not house anything prior to a certain year, so I was not able to put that in the system under this case number. So I created a new report called Calls for Service because I was not tasked with investigating the crime itself. I was tasked with getting a DNA standard and submitting it to the lab. So I created a Calls for Service report under OCA number 11-040183, and I was just told to refer it to that case number.
Right, but you in your own report say if you want to know the details of the case, go look at this file, which the cover sheet and list of exhibits is represented by Defendants 32. That's the way things work, right?
Because I didn't have the details of the case, so if somebody wanted the details of the original case, that's where they would have to go to
Right,
find it.
and that's why you wrote this down, correct?
That's correct.
Okay. Now, so to help you out on this narrative, you were asked Sergeant Pennica tasked you to follow up because there had been a CODIS hit to Jermac Jones from the vaginal swabs of Doris Washington, right?
That's correct.
All right. And that you needed a new DNA standard, correct?
Yes.
Your Honor, I'm just going to object once again to the excessive leading.
Overall, I think he's just trying to draw her attention to what he's
Thank you, Your Honor.
after.
Now, did you run Jermac Jones in the computer system on December 7th?
I ran him on our system.
And what did you discover?
He was on probation.
Right. And did you learn the name of his parole officer?
Probation officer, yes.
Probation officer, thank you. And I call your attention to your communications, which is the emails, which is Exhibit 31.
Yes.
And did you obtain from the probation officer on December 7th contact information which included addresses, phone numbers, and emergency contact information for Jermac Jones?
Yes, I received an address and a phone number.
All right. So you had a phone number for him.
That's correct.
Did you know whether that was a cell phone number?
I did not note it, no.
Could have been.
It could have been, I don't know.
Okay. Now, let's review the search warrant for a second. Well, before I do that, so after contacting the probation officer, what did you discover about Mr. Jones and warrants?
He had an outstanding warrant out of Wake County.
And given that he had an outstanding warrant on Wake County, did you develop a plan as to how you were going to get his buccal swab?
Well, at that point, originally I was going to try to get the swab from him through his probation officer at the next meeting, but had he been picked up on the warrant, I would have had him brought in then. And that's what happened first. He ended up getting picked up on that warrant, and I had him brought in to the police department.
Right. But looking at, and again, I call your attention to 1280, your reporting narrative, right? Did you coordinate with Special Agent Cowan from the SBI lab so that she would be available when Mr. Jones was brought in on the warrant to take his buccal swab?
No, that had nothing to do with the actual taking of the swab. That was to find out if they would test the standard if we were able to obtain it.
All right. Well, what plans did you have for having somebody come and take his buccal swab? How did you decide to do this?
Once he was picked up on the warrant and brought to the police department, I got the search warrant signed, and we called forensics on the radio to respond to headquarters to take the swab.
Okay. And you were coordinating this or discussing this with Sergeant Pennica?
Some of it, yes, but not...
He was your supervisor, correct?
He was the supervisor, yes.
Right. And you were working with him on how to do this, how to pick up Mr. Jones, how to get the buccal swab, and how he would be questioned.
We didn't discuss how he would be questioned. I was told to see if he knew anything about the incident and to get his swab.
Well, Sergeant Pennica knew that he was going to be brought to police headquarters, didn't he?
I believe so.
All right. And you informed him of that?
Yes, the warrant squad brought him up there.
Right. So, and you have viewed the tape of I should not call it a tape. You have viewed the recording of the discussions with Mr. Jones, the taking of the buccal swab, and questioning by yourself, and that is Sergeant Pennica in the room, correct?
I did not directly question Mr. Jones. I read him his rights, and he basically executed his right to an attorney, and I could not question him after that.
We'll go over this in detail in terms of the tape and what was said, but I'm simply asking you a very simple question. On the tape, you saw, on the recording, you saw yourself, correct?
That's correct.
You saw Jermac Jones, correct?
That's correct.
And you saw a man come in and talk with him, correct?
Correct.
And that was Sergeant Pennica?
Yes.
Okay. Now, you brought him in to police headquarters in Durham?
I didn't bring him in, no.
Well, somebody brought him in, produced him at police headquarters in Durham, correct?
That's correct.
Right, and he was sitting in a room, correct?
Correct.
And that room has a hidden camera.
That's correct. At the
Where
time,
is that
yes.
camera hidden?
At the time, that camera was hidden in a thermostat.
You know where?
A thermostat on the wall.
Uh-huh. And while that camera was recording Mr. Jones in the the room in police headquarters, could Sergeant Pennica, yourself, or anyone else view that recording in real time as it was going on?
Could someone? Yes.
That was a,
I don't know if anyone was, but someone could have if they wanted to, yes.
right. And that's the whole point of it, right?
I wasn't aware if anybody was watching when I went in the room or not.
Okay. But that is a capability, that you have a hidden camera. It's trained on the individual in the room, could be a suspect, correct?
Yes.
It makes a recording, takes real-time photographs, a real-time recording of the individual, correct?
Correct.
And that's done so you have a record of what officers are asking, correct?
Correct.
And it's also done because it can produce good investigative leads, because you can see how the individual is reacting when the officers leave the room.
Like I said, when I questioned him and read him his rights.
I'm asking a different issue. Just listen to my question, if you don't mind.
I don't understand the question.
Right. You've questioned people before at police headquarters where there was that hidden camera, correct?
Yes.
And you and your colleagues have not only questioned people, there have been people, other officers outside the room watching
When
as
we're
the question.
conducting an active interview, yes.
Yeah. And so the camera is it has investigative capabilities. One officer can be in there questioning a suspect. The other officer can be outside watching in real time what's being done. And one can leave and the other come in. It's built for that, right?
Technically, yes, it's not as close as you make it sound, but it's several rooms down a hallway.
Right. And because it's important in terms of interviewing techniques for one officer to see what the other has asked before you go in and ask more questions of somebody that could be a suspect in a homicide, right?
If this was an active interview, yes.
When you say an active interview, I guess my definition of an active interview is when officers are asking questions and somebody's responding.
Once somebody lawyers up, it's no longer an active interview for our purposes.
Well, let's get into that for a second. Now, you filled out a search warrant in this case. Let's take a look at that. That's Defendant's Exhibit 30, correct? And so I call your attention.
It's not complete, it's missing page.
Well, which page is it missing?
The very first page.
All right, well, if you want to review, I really want to call your attention to the affidavit and statement of probable cause that you filled out, which is at base stamp pages 1273, 74, and 75. You can look at it on either a big copy of all your communications, or you can look at it on what I've marked as Exhibit 30, okay?
Yes.
And let's review this, okay? In the first paragraph, you identify yourself as a police investigator who is assigned to the Durham Police Department's Criminal Investigation Division, the Homicide Unit. Is that right?
Yes.
And so when you were getting this buccal swab from Mr. Jones, you were working in the Homicide Unit.
I was employed, yes, in the homicide unit.
And how long had you been working homicide?
I started homicide in 2006,
So you'd been working a homicide for 5 years?
at the time, yes.
Okay. And you note here that before you were in homicide, you were in uniform patrol and an investigator in the Criminal Investigations Division Juvenile Unit and the Violent Crimes Unit.
That's correct.
And you indicate that you had participated directly or indirectly in numerous criminal investigations which have been prosecuted in the state, correct?
Yes.
And you also, in paragraph 2, indicate that you had an advanced law enforcement certificate from the North Carolina Department of Justice and Education and Training Standards, correct?
That's correct.
And you had been appointed to the rank of Master Officer.
That's correct.
And that you had successfully completed Police Law Institute courses which covered the mechanics of arrest, search, and investigation.
Correct.
And in paragraph 3, you indicate that you had successfully completed courses that included training on interview and interrogation, right?
Yes.
Crimes against persons, correct?
Yes.
Sexual assault investigations, correct?
Yes.
Child death investigations, yes?
Yes.
Homicide investigations, correct?
Yes.
And crime scene investigations.
Yes.
And you drafted numerous search warrants and associated affidavits.
That's correct.
Now, in your training on interviewing and your experience in homicide, certainly, part of your training in terms of interviewing potential suspects was to be on the lookout for false exculpatory statements.
In an interview, yes.
Okay? Because you were trained and you know from your own experience that a false exculpatory statement can be powerful evidence of guilty knowledge, correct?
Correct.
And even guilt in a homicide, correct?
From an interview, yes.
And as part of your training and practice in interviewing, you are directed to make assessments of the credibility of suspects you're interviewing, correct?
To an extent, yes.
And one of the things you're trained to do is compare the answers that they're giving you to hard forensic evidence to see if they make sense.
In an active interview, yes.
And another thing you're trained to do when you're interviewing a suspect is to see whether that individual gives contradictory answers, correct?
In an interview, yes.
Because contradictory answers can, again, affect the judgment about the credibility of the individual. Fair enough?
In an interview, yes.
Your Honor, once again, I'm just going to renew my objection to the leading if he wants to testify.
Overruled.
Now, in addition to the answers, were you not trained that it's important for an investigator to look for other behavior on the part of a suspect to assess whether that individual is showing consciousness of guilt of a crime or consciousness of guilty knowledge about a crime?
There's different things to look for when you interview somebody. So yes, when you're actively interviewing a person, which I was not able to do in this case, then yes, there are other things that you would look for during an actual interview.
Now, you've done sex crimes cases.
Yes.
You're knowledgeable about DNA testing.
To the extent of what I'm required to do in my job, yes.
Right. You had some knowledge of what RFLP procedures were?
RFLP?
Restriction fragment length polymorphism testing?
No.
Were you made aware that there was some restriction fragment length polymorphism testing done in connection with this case as to semen found on the Nishonda, Washington?
As far as the types of testing and what you're speaking of, that's a little beyond the scope of my training.
So you didn't know anything about the type of tests, but you just knew there had been DNA testing?
That's correct.
Okay. And, but you knew about CODIS hits, you've been trained in that.
Yes.
And you know what STR or testing is, do you not?
STR?
Yeah, STR. Never heard that expression before? Now, let's go back to the search warrant. In paragraph 4 of the search warrant, you swore that the information contained in this affidavit is based on affiant's personal investigative efforts and efforts of other officers and detectives with the Durham Police Department. This affiant has also received information regarding this investigation from other local, state, and/or federal law enforcement agents, officers, as well as other reliable sources of information. Since this affidavit is being submitted for the limited purposes of securing a search warrant, the affiant has not included each and every fact known concerning this investigation, right?
Yes, that's
You wrote
very
that,
cool.
you swore to that, correct?
Yes.
All right. Now, did you know that it was the prosecution's theory in this case that Darryl Howard acted alone and there was one perpetrator?
No, I was not aware of that.
All right. Did you know that it was the defense theory in this case that there were two perpetrators?
No, I did not.
Did you know that it was the defense theory in this case that there were two perpetrators and that both Doris Washington and Nishonda Washington were sexually assaulted?
I was not informed of that at the time.
In paragraph 10, you indicate in the search warrant, in asking for the search warrant, that as part of this ongoing investigation into violations of North Carolina general statutes, it is material and relevant to conduct supplemental forensic exams of the aforementioned evidence. In order to complete the supplemental exams of certain evidence recovered in this investigation, it is required to obtain a DNA standard from Jermock Sharon Jones, correct?
Correct.
And so, by violations of North Carolina general statutes, we're talking here about the homicides of Doris Washington and Nishonda Washington, correct?
That's correct.
And you were telling the court that it was important as part of this ongoing investigation to get this DNA sample from Mr. Jones because it would be material and relevant to the ongoing investigation. Fair enough?
To compare to the codicil, yes.
Okay. Now, in your training, have you ever been instructed or in your own work use something that is sometimes referred to as hold-back facts?
Hold back facts?
Yeah. Have you ever, as a law enforcement officer, or have you ever been trained that sometimes law enforcement will not reveal certain facts in an investigation to the public because it could be you, if you find some informant later on that knows a fact that only the police and the real perpetrator would know, that would be important to the investigation.
I've never heard anything called holdback facts, but I mean,
What expression
when
would you use for that?
have an active investigation, you don't release details of the investigation to the public, but you release the investigation information to the DA's office and any other law enforcement personnel that is required to know about it.
Right. What I'm trying to get at, and see if you can help me with this, is that you've been trained that sometimes it's an important law enforcement tactic to withhold certain information from the public so that in the course of the investigation, if you find, let's say, an informant that gives you information that only the real perpetrator and the police could know, you would have some greater confidence in the reliability of the information the informant is giving you.
Are you talking about this case specifically or any case?
I'm talking about in general.
Because I mean, if you're investigating a case that just occurred, then during that investigation, you don't want to release information to the public because it might prevent you from making an arrest in that case later on, but
Well,
know how that applies here.
you've never been trained or it's never been called to your attention that sometimes law enforcement will withhold a fact because if, let's say, a suspect knows it or an informant knows it, and only the real perpetrator and the police would otherwise know that fact, that would be important to the investigation.
In a current ongoing investigation, yes.
Thank you. Now let me direct your attention to, where's it? Show you what we're marking as defendants 33.
Yes.
Now, if you look at 32, that's the Detective Division file, you see that there is an exhibit listed number 9, intelligence report by J.T. Muse dated 12/1/91. Do you see that?
I see that, yes.
Okay. And do you see what I've given you as 33, a document of 2 pages that you can see is an intelligence report from Protka to J.T. Muse? Do you see that?
It's a routing slip memo during police department, doesn't say.
Okay. Now, have you discussed this at all, this particular memo, with Investigator Protka or anyone with the prosecution here?
No, I've never seen this before.
Okay. And I'd like to review this with you for a second. And, Your Honor, if you don't mind, I'd like to put up the board here. Okay? Now you can see that, have you ever seen forms like this before?
I've seen this type of a notepad before, yes.
Okay.
It's just a notepad.
And you see that it's dated December 1st, 1991.
Yes.
And that's soon after the homicide in this case, correct?
I don't know what the original date was.
November 27th, 1991 was the homicide. Is that refresh your recollection?
Yes.
And you see that this document says, reference double homicide, arson, Kew Gardens. Informant advised me that subjects were probably murdered because mother owed $8,000 to drug dealers from either Philadelphia or New York. Informant stated that many residents in Kew Gardens were offered $2,000 a week for the use of their apartment, but apparently not many accepted. Informant further stated that the perpetrators were believed to have, I should have noticed, oops, it's a problem I have with this, Your Honor, I apologize. Perpetrators were believed to have left behind 4 bags of drugs in the apartment and apparently found some contents missing when they came for them. The perps then told the victim, 10, she owed them $8,000. When perps came for the money, they first raped her before strangling her. The 13-year-old daughter may have unknowingly walked in on the scene, so then killed her. You see that?
I see that, yes.
Okay. Now, based on your experience and training, this is very specific information.
It sounds like it, yes.
I mean, we're talking here about the amount of money that was owed, $8,000, correct?
Correct.
We're talking about how much she was being paid a week for the apartment, correct? That's very specific, isn't it?
Yes.
And then it indicates here that first the perps came for the money and they first raped her before strangling her, correct?
Correct.
And the her, based on your knowledge of this case, would be Doris Washington.
Based on what I've heard in court yesterday and today, yes.
And you know she was strangled as well.
According to what I've heard today, yes.
Now, take a look on the handwritten note on the side of this page. Do you see it?
Yes.
It says, Dowdy, there may be something to this. I don't remember any public info on the rape. And you see the initials EES, correct?
That's what it looks like, yes.
And do you know those would be consistent with the initials of Police Captain Sarvis, correct?
I don't know what his middle name is and which Sarvis are you referring to? I was not
And
here in
there's a father and
91.
son, correct?
Yes, there were two of them. One was before my time.
All right. Well, the one, it was 1991 was before your time, correct?
I did not live here, no. And then
Well, I would represent to you that Police Captain Edward Starvis was in fact working then, police captain, and we can show, I don't know if you haven't reviewed any of the press clippings from this case?
No, I have not.
But if you did, I represent to you that he gave statements to the press, okay?
Okay.
Now,
That must be
based
the-
on your investigative training, he's indicating to Detective Dowdy, you know that he was the lead investigator in this case, correct?
I found out that this week, yes.
And he's telling Hughes and Proctor, other investigators connected with the investigation, correct? To the best of your knowledge?
To the best of my knowledge, yes.
Okay. He's saying there may be something to this because I don't remember any public information concerning a rape. You see that?
I see that it says that, yes.
Right. Well, would you not agree that what you were investigating, withdrawn, would you not agree that what you were tasked to do here was get a buccal swab from an individual that it was now known had left DNA in Doris Washington, correct?
Correct.
And so that was not known. There was no semen recovered, no DNA testing done at this first trial, correct?
I don't know what was done at the first trial or not done at the first trial.
Well, you had no information that there was DNA testing done at the first trial, correct?
I didn't have any information that it was
Right.
done.
So, but you were aware at least that it was your job to get a swab from Jermac Jones because you had information that his semen was found in Doris Washington, correct?
That semen matching a CODIS hit, yes, was
Right.
not found.
And that would be at least 10 markers. You knew it was, if it did in fact match Jermac Jones, that this would be an association with of a very rare type.
I didn't know what association it would be, other than that it would go to show that that was in fact his standard.
Right, you understood that
sample.
much about CODIS and DNA, that if you got a hit, and it turned out it was in fact Jermac Jones's DNA, that there would be a statistic, something on the order of magnitude of 1 in 20.7 billion in a population. Yeah,
I don't know the numbers, but I was never informed of what the outcome was of that.
but you've heard it in testimony. Before.
Yes.
Okay. So, would you not agree with me, based on your experience, training, and what you know of this case, that the fact that there was now semen found in Doris Washington, right, corroborates that there was a rape, something that was not public, and something that this informant knew?
The only thing I can say with certainty is that his semen being in Doris Washington shows that there was some type of sexual act. Whether it was rape or consent, I have no way of knowing that.
Well, I'm not asking you about...
You
weren't
asked
there,
me if it was a
right?
rape.
Right? You weren't there. I'm only asking you for a fair assessment as a master officer, as a trained officer doing homicides and sexual assaults, when you have an informant who says that Doris Washington was raped, and the fact that she was raped was not made public, right? Isn't that the kind of corroboration of a non-public fact that law enforcement look to in order to be sure that the information they're getting is reliable?
I didn't have this. You're speculating that I had this information.
I'm not saying you had it. I know that fair enough that
Your
you...
Honor, once again, this calls for speculation, wild speculation of stuff that she didn't know, that she doesn't know, and he's calling for her to speculate based on some old case that was not investigated on her, and I respectfully reject.
I don't think that's his question. He's asking her about information that a trained officer would know. He's not asking her what she did. He started out his entire premise speaking in general. And he's getting more specific about what an officer who investigated would be looking at. And either she has an opinion about this or she doesn't.
Would you agree?
So then he is tendering her as an expert.
I think
She's
you
trained.
told the court when you got a search warrant that you had training, right? Extensive training on investigation of homicides and sexual assaults.
I'm
Right?
sorry, what is the question?
In your search warrant application and your testimony here today, you agreed that you had extensive training in the investigation of homicides and sexual assaults, correct?
I've had training in both of those subjects.
And we had some questions and answers before where I asked you about holding back facts from the public. You recall those questions?
Yes.
And the point of those questions that in general sometimes law enforcement holds back facts that if they get it from an informant, right, and it's something that only the real perpetrator and the police would know, that is a way of increasing your confidence that the statement of the informant is true.
It can be, yes.
And all I'm asking you, and I realize nobody showed you this or discussed this with you before you went to get the buckle swap from Jermac Jones, but you recognize this was a memo in the investigation on December 1st, 91, right?
It appears to be, yes.
And here, Sarvis is telling Dally, there may be something to what this informant says in great detail, because I don't remember any public information about the rape. Fair enough?
Fair enough.
And perhaps if you had known this information when you were talking with Mr. Jones, you'd have realized that if he in fact had committed a sexual assault, and it was his semen in Doris Washington, correct?
It was his semen, yes.
All right. That given this memo, this was potentially pretty good evidence that the person whose semen was in Doris Washington had committed the crime.
I was not able to interview Mr. Jones, so I'm not understanding your question.
I'll withdraw. Now, Your Honor, I know that we're at 12:20, and I wanted to, I'm about to introduce into evidence the video or the recording of the questioning of Mr. Jones by Ms. Investigator Susi, and she's told us Sergeant Pennick. And I have been discussing this matter with my colleague, and I understand her objections, but I wanted to lay it out for you first so that you can make some rulings. First is, we have from them a recording that I believe is, what is it, Lisa, an hour? What? Yes, if you watch the whole thing, it's an hour and 52 minutes. We have also tendered to the court and to our colleagues, I think at least 2 weeks ago, if I'm correct, the week of August 15th, a certified court reporter's transcript that was the best effort at recording what was said. Some of it is inaudible, some of it maybe people will hear something different. My colleagues indicated to me, and I think Investigator Susi indicated yesterday, that, and Brittany, I'm sorry, I don't know your last name. And Brittany Edwards from the prosecution team, we talked about this last night. I first offered to them another version of this that is 48 minutes long instead of an hour and 52. It contains all of the talking. There were, on this recording, long periods of time where Mr. Jones is just sitting there, not either talking into the telephone nor answering questions. So, number one, I wanted to make you aware of that. Number two, I offered them the opportunity to make any changes, anything that they heard in the tape that is not in our transcript, because I readily admit that one could hear more or less. And it is my plan, these are exhibits they gave us, what I would prefer to do is, number one, offer the recording as the best evidence. Number two, proffer to the court and the witnesses so we could follow along the certified transcript of the court reporter. Number three, at any time if the witness hears something different, or any time after we're finished with this, they want to give us their notes on what they hear is different, that's fine. But I think the transcript would be a good guide for the court in order to follow this. And my ultimate proposal would be to use the shorter version because it saves a considerable amount of time and I think gets to the point. Having said all that, we did talk about this and I understand, I think it came up at the beginning of the hearing, that the prosecution is going to object to this recording. I don't believe on the grounds of authenticity they proffered it to us. And in fairness to them, I think it's fair to say that until we informed you that there was a recording on it, they hadn't seen it, right? And hadn't disclosed it before. So we believe that even though they may claim that Mr. Jones had invoked his rights under Miranda and wanted an attorney present, that may present, not necessarily, but it may present certain problems for them in terms of introducing evidence against him if he were ever prosecuted. But when it comes to Mr. Howard, the statements that Mr. Jones made, we would submit are probative and tend to prove that Mr. Jones has guilty knowledge of this crime, and that is evidence that was derived directly from the CODIS hit, which can be considered as newly discovered evidence on the DNA favorability hearing, because it could be played to exculpate Mr. Jones at a new trial. So we're going to offer that. I don't, Stormy, you want to argue first against the admission of it, and then we can get to the mechanics, if that pleases the court?
Your Honor, if I may, what we stated was that we would stipulate to the best evidence rule, which is the recording. I don't have a problem with that coming in. But me and my team, we did have an opportunity to view the shortened tape. The quality is poor. It is jumpy, and it's not worth it to us for the extra 10 minutes. So I have no problems with the original tape coming in. The only other issue that we had advised him...
Excuse me, Stormy, it's not 10 minutes. It's an hour.
Okay, but you said 40 minutes versus an hour.
No,
20 minutes.
40 minutes, 48 minutes
Okay.
versus an hour and 52. And that's why I raise it, Your Honor, for purposes of this. By the way, I don't object at all. I think it would be proper to admit, because this, after all, is for the court to decide, and you have the opportunity. The best evidence is going to be the recording. You can take it back and watch the whole thing, right? Or you can take parts on cross-examination of things that are not in the shortened version, but are in the longer version if you think they're relevant, and play those. But my proposal is to put in the entire tape as an exhibit, but also to put in the shortened version for purposes of playing it in court and questioning the witness and putting that forward in order to save us a considerable amount of time, and also to use the transcript as a guide. That's my proposal.
And Your Honor, once again, we have discussed it with the team, and we've looked at the tape. We have no problems with the full tape coming in and going back and forth if that's necessary. That is an option. The tape that they have tendered, Your Honor, is not of good quality. It's jumpy, and we don't feel that it is a fair and accurate depiction of what happened. Furthermore, both the officer, Susie, Miss Brittany Edwards, and Mr. Dale Morrill and I have gone through the transcript on numerous occasions. In fact, last night he asked us if we would go through the transcript and see if there was any tweaks or things that we would make. We found so many errors and so many omissions that we could not, there's no way that we could spend that much time and resources to fix the items that were mistaken, not said correctly, or simply omitted from the transcript. So we feel that the best evidence, we have no problems with the tape coming in, played as a whole, and you can follow along with the thing, but we would greatly state that the transcript does not follow what is going on in the tape.
Your Honor, I mean, ordinarily, I think this would be considered, you would charge a jury, probably have charged a jury many times, that the best evidence is the actual recording, and any proffered transcript is only an aid to the fact finder to follow it, and any that she's perfectly free on cross-examination of this witness to point out in any particular section of the certified court reporter's transcript what she thinks or the witness thinks is different, right, or is additional. And I think that's fair. They can take all their notes and they can do that. My only suggestion is that we use the shorter one because time is precious. The court's time is precious for sure here, and we want to get finished. And that if there is anything that they feel is left out or should be added, they should be free to play that on redirect examination of the witness. And again, the tape itself is the evidence. Court will have all that to examine.
And Your Honor, I just once again argue that the best evidence rule is the evidence. Let's put the evidence in. It all comes in. Look at the totality of the evidence and not something that has been manipulated. And when I say manipulated, any time that a video is spliced, cut, or edited in any way, it's manipulated. Your Honor, you're the trier of fact. You can listen to the whole tape. You don't need a transcript to go through, especially one that is not consistent with a lot of the statements that are going on in the video. Furthermore, Your Honor, I would state that time is precious to the court, and that's one of the reasons why we want to take the time now to go through all of it and get it right.
Well, if you play the long version, which you both agree is an hour and 52 minutes, you all want to sit there and watch somebody sitting in a chair doing nothing? You can't agree to speed through?
Your Honor, we can agree to speed through, but I'm not going to agree to an edited version.
Your Honor,
I'm not talking about an edited version. I'm talking about the
right. We can't.
original. I don't want to sit and watch somebody sitting in a chair for 40 minutes.
Right. That's why we did it this way, Your Honor. I'm sure my colleague will stipulate that however jumpy the version is, everything that's spoken on the long tape is on the shorter one. The only thing that we attempted to splice out are those periods where he is sitting alone, silent, not talking on his telephone and not talking to anybody else. So you're not going to miss anything that is spoken, but they can point it out if we did, but we didn't. Given the nature of this recording, it is, I'm informed, impossible in a coherent and technical way. We didn't get a copy where we could just mark it and speed from point 1 to point 2. The only thing that we could do in order to expedite the presentation to the court is to make these cuts of the areas where he's sitting alone and he's not talking, either on his phone or to any of the officers. And so that's our proposal. We'll introduce both. The best evidence, the long version, will be available. They can refer to it. The court reporter's, certified court reporter's transcript will be available for you to look at as a guide and to work with the witness so we know where we are. It is not, it's only an aid. It is not the best evidence. The best evidence is the long tape.
All right. I think we will do this as Mr. Scheck has proposed. So what we're going to do right now is go to lunch, and we're going to come back at 2:30, and we will proceed at that point. And I understand now you're going to introduce both of them.
Yes.
And you can have access, the court and you all can have access to the transcript to go along, or then any issues that the state has, they can point that out in some other point of the trial,
Right.
or examination of a witness, or redirect, or whatever.
Yes.
I think that makes sense. I mean, that way your tape is preserved for whatever record you want to make of it. I assume this would be for some other court, if an appeal is necessary. At least that panel can have whatever both of you looked at.
Thank you, Your Honor.
All right. All right, Mr. Deputy, 2:30.
Court's in recess till 2:30.
We need a moment with Darryl. If that's okay, we need a moment to talk with him. Can we do it over there?